The Karnataka High Court on Wednesday, 9th February, has referred the petitions dealing with the right of Muslim girl students to wear hijabs or headscarves in their classrooms to a larger bench. Till now, a single judge, Justice Krishna S Dixit, was hearing these matters. He conducted 2 hearings on Tuesday and Wednesday. On Wednesday, he held that this matter needs to be referred to a larger bench and has asked the Chief Justice of Karnataka to do this as soon as possible. According to him, and I quote, "Having regard to the enormity of questions of importance which are debated, the court is of the considered opinion that the papers be put to the hand of the Chief Justice to decide if a larger bench can be constituted in the subject matter." Now, why has the judge done this? According to the judge, he says that there are serious issues of constitutional law involved because along with the argument that these girls have a right to privacy and a right to freedom of expression under Article 21 and Article 19 of the Constitution, which would allow them to wear the hijab, they've also argued that the petitioners have argued that this is also a matter of Article 25, the right to practice one's religion. Now, when it comes to this article, the government is allowed to make, to restrict the ability for a person to practice their religion in terms of, the objectives of the state, in terms of security, in terms of, for instance, you can't say that, because of my religion, I can't follow the criminal law of the state. But when it comes to personal law matters and individual choices, a person has a right to practice the religion of their choice, and essential religious practices cannot be curtailed by the state. Now, the argument, of course, is the wearing of a headscarf by a Muslim girl, is that something which is part of an essential religious practice? The Kerala High Court had in 2016 held that it can be said to be so. They'd allowed Muslim girls sitting for the All India the medical entrance test to wear these hijabs during this time. They recognized this right. However, there is a sort of conflicting decision, not a directly conflicting, but a partly conflicting decision from the Madras High Court from 2006, which had allowed the publication of electoral rolls which had photos, including those of Muslim women. Now, at that time, there are certain observations in that order from 2006, which do seem to refer to the fact that this may not be considered an essential religious practice, and therefore there is a certain matter of debate which has to be settled by the courts in this. Now, that is something which a larger bench is going to do. The single judge, Justice Krishna Dixit, has requested that this be taken up at the earliest. He's asked the registry to list this before the Chief Justice of the Karnataka High Court immediately. What is surprising about this order, however, is that there is no interim relief granted. As most of you will be aware, there have been a great deal of disruptions in Karnataka over the last few days regarding this. We've seen videos emerging from yesterday of stone pelting, of saffron flags being hoisted at colleges, of the heckling of Muslim girl students trying to attend their colleges. As a result, there was a compelling interest in saying that these students should be protected, they should be given a right to attend their classrooms till such time as the court makes its decision, which may take at least a few days, if not weeks. There, as was pointed out in the court today, after 2 months, there are going to be exams across the state. So in this context, it was perhaps required to have an interim relief order in saying that till such time as the court makes a decision, these girls should be allowed to attend classes without any interference. However, the court has not done that. It is now up to a larger bench to make that decision when the matter gets listed before them as an interim order. So stay tuned to the Quint for all the updates on this. We will be giving you all the updates on the ground in terms of disruptions, in terms of what's happening and what's happening in the courts.